Start. The legal landscape is a complex web where every deletum or wrong requires a specific department to oversee the deposit of legal documents and the formal deposition of witnesses. Stop. In this pursuit of justice, those desiring a resolution must never desist from their efforts to destroy systematic corruption, even when faced with destroyed records or the destroying force of time. Stop. Authorities may detain a suspect, but the detention is always subject to a determination of its lawfulness to prevent any diminution of civil rights. Stop. Whether a direct order or a specific direction found in a legal directory, every discharge of duty and every discovery of evidence is subject to the discretion of the court. Stop. This discretionary power must never discriminate or be applied discriminately, for discrimination that is discriminatory undermines the law. Stop. When a discrepance or a significant discrepancy arises, parties must discuss the discussed matters in formal discussions. Stop. It is often discovered that a dishonest actor led to the dismiss of a claim, though a formal dismissal of a dismissed case can sometimes be appealed. Stop. Even in cases involving disorderly conduct, one must dispose of the assets according to the final disposition, especially when a dispute or multiple disputes lead to the dissolution of a partnership. Stop. This process often causes distress within a district, creating a disturbance and disturbing the peace. Stop. A divergence in testimony may lead to diversionary tactics, especially when a dividend or a corporate division is at stake. Stop. Whether it is a divisional conflict or a bitter divorce, the docket remains full. Stop. Next, the doctrine of law requires every document and documentary trial to be scrutinized at the domicile where the act was done. Stop. Often, the dotted line of a contract is signed in doubt, leaving a dying wish or an easement, be it a standard or easementary right, in jeopardy. Stop. Like a solar eclipse, the truth may be hidden, but education on the effect of an effective ejectment is vital. Stop. Following the principle of Justum Generis, an election of remedies may be electronic, allowing for an emancipated youth to seek emancipation stop, from the right of preemption to the warning of caveat emptor, comma, the enjoyment of property is rarely enough without a formal inquiry into the entire entirety of the environment. Stop. Next, current equitable and environmental standards ensure that an equitable solution is reached even if the court erred on essential points. Stop. One must est bracket be ready to establish an established establishment upon an estate, comma, ensuring that estoppel prevents vacuous from using evasive maneuvers. Stop. By the evening of the trial, comma, an eviction based on evidence that is evidential, comma, evidentiary, comma, or evidentially sound must be processed. Stop. An examination of the examined materials by the examiner often reveals excessive fees in an exchange of excise duties. Stop. This exclusion of facts during the execution of an executive order by executors can lead to exemplary damages. Stop. Next, an exemption granted to an expert who explained an explanation regarding explosive must be expressed, comma, as the expression of extenuating circumstances is extra bracket outside the norm. Stop. On the face of the fact, comma, both de facto and de jure facts shows that if the defense failed, comma, the failure was not for lack of good faith. Stop. Whether it involves the family, comma, the father, comma, or a specific fault, comma, the court's favor remains with the law. Stop. A felony filed in a financial finding by a firm and fixed hand follows the path of food safety and the force of foreclosure, comma, as mentioned in the foregoing. Stop.